Hi everyone, Derek Johnson with Tatango.com. I'm here at Innovista Law, home of the TCPA Defense Force. I'm sitting with TCPA attorney David Carter. Now, over the last few years, we've seen a significant increase in TCPA, lawsuits, federal lawsuits. Right. And I have some numbers here which are pretty shocking. I need to double check them just to make sure they were true, because they are very shocking. 2007, which was only a few years ago, there was 14 cases, TCPA cases in federal court across the entire United States. So essentially very little, none almost. 2016, last year, there were nearly 5,000 cases. I don't even know how many multiples that is from there, but why is this happening?
Sure, and unfortunately, I think we're continuing to see the trend line increase.
Okay, so it's going to keep going.
As far as we know, that we're not having a slowdown, and there's a couple things that are really driving this, right? The Telephone Consumer Protection Act is one of the few federal laws that has minimum statutory damages.
Okay, explain that to me, because I'm a regular person.
So for lawyers, those are very exciting words. But what that means is, in most cases, if you're in an automobile accident, for example, and someone rear-ends you and you end up suing them for damages, you have to be able to come into court with some evidence that you've actually been harmed. Okay. So you would get the repair bill for your car, you'd look at your medical expenses, and you may be able to prove not just what the expenses you've incurred to the point of the trial, but that you're going to continue incurring expenses.
You have to have
some evidence, right?
Evidence.
You have
Makes
to show the court, the jury, other people, like, here's really the cost to me for this particular harm.
Sounds reasonable.
Sounds reasonable. That's the way the vast majority of litigation works in the U.S. Court system. The Telephone Consumer Protection Act is one of those few exemptions or outliers from that requirement, because what Congress did when they adopted the law in 1991 is said, if you received a telephone solicitation call, FCC has extended that to text messaging.
Okay, so it now includes text messaging.
Includes text messaging, and you have not authorized that call or text message, then you can go to court and you can get $500 for each call that was not authorized.
So even if you didn't pick up the call, even if you didn't see the text message, just because you received it.
Because you received it. If you probably do have to pick up the call, if it actually is a phone call. But if you get an unwanted text message that's not been authorized from a company, you don't have to prove that your time that it took you to read those 160 characters was worth $500. I mean, most people's time is not worth, if it's $100 or $500 a second, right?
Yeah, especially a text message. There's 160 characters.
Right.
Okay.
But you don't have to go to court armed with evidence that your time is valuable and that you would have generated $500 off of that time.
You just have to prove that you got a text message.
Correct.
And that's all.
You have to prove that they violated the TCPA. And then the law implies damages of $500 for that. And it's $500 per message. So if you think about like a text messaging campaign that maybe they send 2 or 3 messages a week, and if you let that go on for several weeks, you have, in fact, a weird incentive to
keep it going.
Because you're going to get $500 every time you get this message, right? Yep. And then you have the potential, and we'll talk about the fact that if you can show there's a willful violation, a knowing violation, that $500 can actually become $1,500
per text message.
Per text message.
Okay, so this is adding up really quickly.
It's adding up very quickly, and then so those are two big factors, right?
So no proof that you were harmed or it took a bunch of time and it was annoying. It's essentially you just got a text message you never asked for.
Correct.
Okay, and then you get to claim anywhere from $500 to $1,500 per text message. So you get 100 text messages, it'd be 100 times $1,500. I don't even know what that number is, but it sounds very large.
Talking about large numbers.
And that's one person.
So that's one person. Okay. So then, second factor, right? These cases are not getting filed as a one-person case. So instead they're getting filed as what's called class action cases. So when Congress adopted the Telephone Consumer Protection Act in 1991, there was a vision, and you can read in like the legislative history, this vision that you, Derek, would feel like my privacy has been violated. I've got these unwanted phone calls. I'm going to take the company that's making the phone calls to small claims court,
Okay, yeah.
and I'm going to get my money,
Yep.
right? I'm going to
Most
do this.
you don't need an attorney there. You can just usually sign up and go.
Yeah, and so it's like an
Here are my
individual
grievances.
enforcement action.
Okay.
So that in part is why the damages are $500 or $1,500.
Makes sense. I'm wasting my time going to court.
I need to make it
Small
worth
claims
people
court,
because
yeah.
otherwise, if it's like if I had to go prove damages or if it was $10,
Yeah.
then I wouldn't take the time, and then I would continue to get these nuisance.
And there'd be
phone
more
calls.
spam text messages and phone calls because there's no real like stick to
To stop
incentivize people
right?
to stop people.
Correct. So they thought, I need to make the penalty high enough that
Makes
it's
sense.
worth people's time to go and essentially be their own enforcement action,
Yep.
right?
Yep.
And that will save me from having to have like the Federal Communications Commission policing all these things or these federal agencies involved.
Okay.
I can just get all consumers to be like their own police person. That will help to cut down on this
So
problem.
it sounds almost fair because I guess up until now, I've thought $500 to $1,500 per text message almost seems kind of unfair, like ridiculous.
Yeah.
But now, if you think about it, it was designed so consumers can go, and I would spend 3 hours, at small claims court,
Sure.
arguing my case, and maybe that's worth my, the $1,500. I'm not saying I'm that expensive, but
Right.
Okay, so what has happened? Because it seems like something definitely has maybe changed.
Yeah, so what's happened is instead of most of these cases proceeding in that manner that was originally envisioned, what's happening is there's plaintiffs' attorneys that are really pursuing these cases on a class action basis. And what that
Okay.
means is they find an issue or a company that has potentially deviated from the requirements of the Telephone Consumer Protection Act, or they've done something that they think they can argue as a deviation, and they bring that as a class action. So anyone that's on the list that fits a certain criteria, suddenly all of the calls or text messages to that list are part of the litigation.
Okay.
And the potential damages rise very quickly.
Because if you, let's say, receive 10 messages times, $500, but then you times that by 1 million phone numbers that are part of that list,
Right.
now you're talking hundreds of millions.
Hundreds of millions
Yep.
of dollars.
Okay.
There's been cases that have been brought as class actions where, the potential exposure,
What they're
not that they
asking
actually,
for.
not that they actually got that much money,
Yeah.
but they, potential exposure in hundreds of millions of dollars.
Wow.
And
Okay.
you've seen in instances where there were issues, settlements, there's cruise line settlements, $75 million settlements on these
Wow.
issues.
Okay.
And
so there's a lot of money, I guess, to be made here.
There's a lot, exactly.
Okay.
There is a cottage industry of plaintiffs' attorneys that have realized that they can, if they succeed on a case, they could have a great windfall in terms of money.
Yeah.
But even the threat or the fear that they might succeed and the fact that the damages could get so high is often enough where they bring claims and then get good settlements without actually having to prove the case because the exposure, the risk of if they do succeed in court,
It could be huge.
It could be huge, right?
Okay, and it's a court like you're going in front of. Is there a jury usually?
There could be a jury. I mean, most of the time, if you're talking about a class action case, the plaintiffs are going to want a jury because they're going to think that the jury will be potentially more sympathetic.
And as a brand, the jury, you don't know which way they're going to go.
Well,
you have an idea, but it can go
either way. And when you go all the way through trial, and as a brand, you have to appreciate that you're probably going to be seen as the party with deep pockets.
Yep.
So that's where the risk
against
comes
the
in.
little person, the one person
Right.
that I guess led the class action lawsuit.
Yes, exactly.
Okay.
So you might have one or more
Okay.
of the named plaintiffs, they're called, that would be actually in the court testifying there.
So it seems like a big company kind of bullying the consumer, even though really that maybe isn't the case.
Correct.
That's what it could seem like from a juror's perspective. So that's maybe why we're seeing so many settlements instead of taking it all the way.
Sure.
And it's costly, isn't it?
It's
Just to
costly,
defend yourself.
Right. The process of going through the litigation itself is not only costly because you're hiring attorneys, you're hiring expert witnesses to testify, but you're also, of course, distracting some of your key employees from the business opportunities that they might otherwise be working on. So it becomes costly not just in the damages part, but in actually doing the litigation as well. So we talked about two issues, right? We talked about the lack of or the $500 minimum statutory damages. We talked about class action.
Yep.
And then there's a third issue that's related, which is in a lot of other federal statutes that have statutory damages, like the $500.
Okay.
They will say it's $500, but no more than $10 million.
Okay, so
right?
they put a cap on it.
They put a cap,
okay.
and that sort of helps to, again, they look at, well, that's a pretty significant amount of money, and you probably don't want to willfully violate the law and lose $10 million or $20 million. So the cap helps to kind of create some upper limits of exposure, and therefore to make sure that you don't necessarily have this explosion of litigation.
Okay.
That
Like interest from people that just want to, do litigation to earn money,
right,
because they see that if there's no cap, it's kind of like a sales commission. If there's no cap, they're just going to keep selling, and they're going to keep selling, until the cows come home. But if there's a cap, they're going to sell almost up to that cap. Sure. And then it kind of stops.
And it also changes, having a cap changes the perspective of the company that's being sued about, is it worth the risk of,
because the jurors could say it's $1 billion.
Correct.
Like there's no cap technically, so
even if I write that I did not violate the TCPA, I may still think it's worth settling to avoid the potential exposure that something goes wrong.
Okay.
And I get this very big damages award against me, right?
Yep.
And so when you're a company kind of evaluating the risks of litigation, the cap helps to maybe say, look, I know there's some risk, but I know I didn't do the wrong thing. I'm going to go and defend myself, because if I lose, I can survive a loss, right?
Yep.
Where here, you sometimes get into a situation where the potential damages are so significant that you're like, I can't go it's
like
very
the company
hard
doesn't
to
even
go
have that
defend
amount of
myself.
money.
Right, it's so hard to go and actually defend myself and stand up for myself because of the potential exposure that if I lose. So it really changes the dynamics when you're talking from a litigation perspective about like doing the right thing, defending yourself, and what that might mean.
So it seems like it's kind of been a perfect storm. Every little thing has kind of built up to,
this awareness.
Near 5,000 cases in 2016. And that's the amount of cases that were filed.
Correct.
Right?
Yes. Yep.
There's also threats of lawsuits which are not filed.
Absolutely.
So that could be larger.
You have threats. You have cases that might have settled before they were actually filed with the court, so they never get recorded into these
So
statistics.
This is a huge issue.
It's a very significant issue.
This could be even the top of the iceberg. It could be, other
there could be other
threats
absolutely underneath there.
Wow.
And then you understand the significance of this issue when you see commercials on television,
I've seen
advertising for plaintiffs, and I see this. I don't see them a lot where I live, but I've traveled to other places and been really amazed to see lawyers on television advertising to attract plaintiffs to come and file claims, because that's the business they're in now. Is encouraging people to come. So the exposure is real. That's what's led to this rise in cases, and I think it sort of talks about the opportunity that exists for brands and other companies to step up and become more involved and more engaged. We there's a really receptive commission, FCC commission right now, looking at potential solutions, helping to create common sense reforms. But we need companies, and Tatango's doing this, and we need others to continue to be involved in this process and to help the FCC and even Congress understand that these types of really significant penalties are making it much more difficult for good companies who do the right things to feel confident using the technology and reaching consumers. So consumers are being hurt because they're not getting
People are just not even signing up for, or they're not even starting text messaging campaigns or calling their customers when the customers are saying, I want to receive text.
I want to hear from you.
Yeah,
I
exactly.
want to get these messages.
This is the easiest way to communicate with me.
Exactly, and it is the most obviously read and like responsive form of communication right now. And so it's really important from our perspective that if we're going to balance and get rid of these excessive penalties, that's only going to happen when more brands, more companies, more providers like Tatango are involved in the discussion, that go and talk to the FCC, submit comments. There's proceedings that will let them do that. And so we encourage companies to do that, because that's what it's going to take to sort of create a more level playing field.
Because the FCC they're not bad people. They're not trying to make people's lives hard. They're trying to make consumers' lives easier and
Correct.
better experiences. But it seems like they just need a lot of feedback to do that.
Right.
So they're not against us as a provider or a brand. They're actually for kind of everybody.
Sure, and what's happening is, of course, the only people they hear from are the people that are complaining, right?
Okay, yep,
So,
that usually happens.
So those are the loudest voices they hear,
Yep.
And that's kind of where we've gotten to the situation where we are in 2017 with this really excessive amount of litigation and the potential exposure. And so they need to start hearing the other side of the story more,
Okay.
and that can help to rein some of this in.
Okay, and I guess if there are so many, cases being filed, what are one or two tips to avoid, being on the other end of one of these cases, being one of the 5,000?
Sure.
What can you do? I know there's not a blanket thing that you can do that will avoid everything.
Yeah.
But maybe some tips or tricks for our viewers as to how can you be TCPA compliant, and maybe just for text messaging?
Sure. Well, of course, the first and most important for text messaging is getting the right opt-ins,
Okay.
right? And getting the consent, keeping track of those records so that if there's ever a question, you can go back and you can prove without a doubt that you got the consent to send the message.
So all the text message records, the advertisements, the copies of them, everything.
Yeah,
Okay.
you need to keep all those things. You need to keep all those things not just while the consumer is opted in, but you've got to think about the statute of limitations,
Okay.
the Telephone Consumer Protection Act, and make sure that you've got records so that if any point in time an issue arises during the statute of limitations period, you can produce those materials.
And there was that, like 4 years?
That's right, yeah.
Plus, you got to go back to when they opted in. So it's 4 years on the last message they received.
4 years essentially after they opt out.
Okay, so you could be,
yeah.
if they've been opted in for 3 years, that's 4 plus 3. Essentially keep the records forever.
Yeah.
That's what I usually say.
Certainly for quite a period of time. So that's the first thing is like you got to get the opt-ins and you got to keep the opt-ins. And the second thing is because this area continues to evolve and change so much, you really need to work with good companies, good lawyers that are constantly on top of the changes, that are monitoring what's happening at the FCC, looking across the courts, and understanding where are those plaintiffs' attorneys coming in, and
monitoring these cases.
Exactly, and I think those to me, that's the biggest thing a company can do to kind of, unfortunately, TCPA shouldn't be a hobby, right?
Yep.
It's one of those things that really takes diligence and it takes kind of constant awareness of what's happening in the environment, and it's a good to work with a software company that's providing the platform, and lawyers, because there's a practical side of it, and then there's like the legal side of it, and those two things really need to come together.
And I know we put a lot of information out on the TCPA and best practices on our blog, but that does not constitute a marketer to go, oh, I know everything.
Right.
And it's always changing, right?
Sure, absolutely.
So it almost seems like getting an attorney that specializes in TCPA involved is a better solution than just getting a general business attorney or general counsel. You obviously have to include them, but really, like you have to be an expert and live and breathe the TCPA to just keep up with it.
Well, you definitely have to be aware that there's all these different places in which the laws are being evolved, from the FCC to courts and things like that. And if you're not familiar and looking at all those things and you just look at one case from one court, and you might miss the fact that that case is the outlier, right? And that the majority or the trend is in another direction. So those are the types of things that, again, it helps to have people that really look at this issue on a regular
Specialize.
basis.
Just like we specialize in text messaging, that's all we do, that's all we know. You guys specialize in TCPA. I always pick specialists over generalists, so that's good news. Well, not good news that obviously it's on the increase. Last year, up to close to 5,000 TCPA cases in 2016. That's up from a mere 14 in 2007. So that's unfortunate that's on the rise, but we have some solutions, obviously, and hopefully we get some clarifications, and we're calling on brands and providers to, I guess, they don't reach out to the FCC, they reach out through their attorneys or through your law firm to reach out to the FCC.
That's right,
because they're looking for the advice.
They are. They really do. I mean, every time I talk to a commissioner or a staff person at the FCC, there is no doubt that they like to hear from
Okay.
companies. They like to hear from the people really on the front lines doing the work, and that's the most persuasive way.
So this is a positive thing. It's not an annoying thing for them. They're looking for this.
Yeah, and it's also great if you've already built those relationships and you've talked to people, and then an issue does arise.
Oh, interesting.
You're much better off going in with a friendly face to someone that's already met you a couple times,
Yep.
understands your company, versus coming in when someone's
The first
complaining
time.
about you.
Yep.
Right. So we encourage people to be proactive and get out there now, help shape these issues, realize that it can be very valuable to your company to be part of this process.
Okay, perfect. So that explains why we're seeing so many TCPA lawsuits. Again, my name is Derek Johnson with Tatango.com. I'm at Innovista Law, the home of the TCPA Defense Force, and I'm speaking with TCPA attorney David Carter. Thanks for watching our video today. If you like this video, be sure to give us a thumbs up on YouTube. If you want to see more of these types of videos, be sure you subscribe to our YouTube channel. And if you have comments or questions, please leave a comment or question in the comment section below.